Dear friends, the young students of law are going to come out as graduates of law and the budding advocates. This is an effort from our channel Dharma Chakra on various issues of law. What is the position of law? How Honorable Supreme Court is looking at. This is a case where a statutory appeal in accordance with Section 62 of Insolvency and Bankruptcy Code was filed. The main issue we are going to discuss is the Honorable NCLT Chennai bench removed the liquidator by applying the General Clauses Act. The Honorable NCLT Chennai bench removed the liquidator based on a complaint filed by IDBI Bank by applying General Clauses Act 16 and Rule 11, that is invoking the inherent powers. Then the matter went to NCL80, and the Honorable NCL80 also upheld the judgment of, and then it came before the Honorable Supreme Court. In this video, you are going to see how the Honorable Justice Abhay Oka bench, their lordships, as you all know, I don't need to say much, is one of the best of the judges. That is, everybody in Supreme Court, you ask anyone will tell you. And it is a fundamental rights, life and liberty, Article 21, or a civil law, or any law, is like a Justice Solomon who can give solution in quick terms. That is where it is not the law that you're going to go on talk about. You have to understand what the judge, how the judge is looking at your case. So, right. This is statutory appeal means that is the order passed by NCLT can be challenged before NCL80 under Section 61 of the INB Code. No other process is possible. No other court can take it up. And the order of NCL80 will have to be challenged under Section 62 to before Supreme Court. This is statutory appeal. That's why it's called CA, civil appeal. Otherwise, SLP, you know that when the Honorable High Court the division bench dismisses or decides, it will only come under SLP civil. Right. So what are we going to see in this? The law laid down by the Honorable Supreme Court and also the actual proceedings with a transcript, a brief idea. Why? Because this particular law laid down by NCL80 has been used by all the benches of NCLT, 21, 25 benches. When this is a per incuriam order, that is the problem. See, what happens is when the order is made, where is live law, IBC laws and all, they will tell you. Then that will be a judgment to be binding judgment. So NCL80 is the next appeal court. Then the final is Supreme Court decides the law. Right. Now, what is that they said? Let us take up. We'll go to what the law said is, this is the sum and substance of what Honorable Supreme Court has said. It's in the form of an obituary dicta. Application of Section 16 General Clause Act in IBC. When there is a specific provision in the INB Code, which is a complete code, General Clauses Act cannot be applied. That's the law laid down. The adjudicating authority will have to strictly confine to the provisions and the procedure laid down in the code. Because when code is a complete code, you cannot have an equity jurisdiction in this. Right. Next. Of course, the judgment of Honorable NCL80 was running into pages and pages, but then they have not discussed the main issue and applied General Clause Act and removed the liquidator. So, expresses displeasure on long judgments running into 46 pages, ignoring the main issue by Honorable NCLT Chennai bench. Now, what did the law say? What is this law? Section 16, you can read that. And when somebody is appointing, power has got to appoint. The same person has got a power to remove. And then the Lordship said, there is a specific provision. When NCLT is appointing, they are exercising a power. And that power is this. The Insolvency Bankruptcy Court essentially states that adjudicating authority must replace the resolution professional appointed an insolvency case if the Insolvency and Bankruptcy Board of India recommends their replacement for specified reasons. Underline. We know that IBPI will never give reasons. If anybody files complaint, that is the end of that resolution professional. They will search reasons and remove the person. If you see some of the cases, we don't know about all, but then we have enough instances which must be documented in writing, effectively allowing the board to suggest a different insolvency professional to take over the liquidation process. Rule 11. Rule 11 is inherent powers. That also again, when there is nothing is there, liquidate is appointed in the Act of Parliament. So Act of Parliament is superior to Rule 11. It cannot be applied. And that also has been explained. Now, when the matter came before the Honorable Justice Venugopal retired, and Mr. Naresh Selecha, technical member, is there. So they have recorded in that order the proceedings now. At least the NCLT did not record what he said, what you said, and what is their findings, which is mainly important for a tribunal which is governed by the principles of natural justice. So the learned counsel for the respondents, that is a very senior counsel, was appearing for IDBI Bank. And unfortunately, when that gentleman is appearing, nobody listens to the small lawyers. That's why these senior counsels charge 5 lakhs per hearing, minimum 3 to 5 to 7 lakhs. So they will be saying same law, nothing else. Learned counsel for respondent stated that the authority who appointed the liquidator has adequate powers to remove also. The learned counsel for the respondent further submitted that these powers are inherent in terms of Section 16. Read with 276. 276 of Companies Act gives reasons when the liquidator involved is in corruption, etc. Otherwise, why do you use? First of all, when do you use a power? First step is there is something drastic about liquidator indulging in corruption or inefficiency and all. Here there is no reason. Somebody said this man is not the proper or something, where they don't have locus standi also, IDBI Bank. So they have just added all like a maze. And the appellant, myself, that is the person who filed the petition, submitted. Appellate tribunal gave the ruling in judgment, Kiran Shah, where it has been held that there is no provision in the code for removal of liquidator based on the complaint of a financial creditor who is only a claimant in liquidation. This has reached finality. But the Honorable NCLAT did not consider it. It's a binding precedent. If you see, during the tenure of Justice Venugopal, sir, very nice gentleman, but he followed his own law. Either it is code, he never bothered about the code. Precedents, just absolute disregard, which we'll see, discuss step by step. And how you can deal with such situations when the judge follows the same ruling, one law for one client, senior counsel, just opposite law for the other counts. So how can you? And in the Supreme Court, the problem is, my friends, it will not be heard. A notice is issued also, then they will file counters, lawyers will come. 5-6 years it will take. In other words, Supreme Court is not an effective court of remedy. So there is a lot of responsibility at the first level, the NCLT. That we will discuss, but in this case, they have not bothered. We'll take up further. We are talking specific to this section 16 of General Clause Act. So they have asked these questions, and then they agreed with that. That's all. And they have written their reason for removing the liquidator, upholding that. They have read combined 33, 34 INB code. They know that there is a specific provision in the code. Then why are you applying General Clause Act? And they have to discuss that 34 code says this, then this is infirmity. They have not said. We have been telling them this is the law. But they did not take it up. Make it clear that adjudicator which had powers. See, section 16, why do you apply when 34 is there? This is the simple question. You read that. The adjudicating authority has removed. He didn't give any reasons. And the adjudicating authority appointed the promoters, person working with promoters from the list of 100 or 100 chartered insolvency professionals. How is it possible? So, but they have not considered all this. Now Supreme Court, when the matter came up for admission, when they'll appoint very senior counsels who jump on you, then but Supreme Court, it doesn't work out like that. Actually, everybody treats him like a god of justice. You ask them, very unusual. One judge is praised so much by young, old, medium, everybody. But he's very strict and tough judge. Right. Transcript of readings on that day. That is what we have explained you. You can read that. And now we can listen to the proceedings, because this is the main thing for which
compliance with 34 4B has been made. And here, you could have removed 34 4B. And it could also, removal could also be under the NCLT kind of inherent powers. The rules which are no, there's statutory power listing. Yes, the statutory power which says just read 34. Yes, because ID code. Yes, yes. Not sure because the title are not adverted to that account. Just part of 40. This is the only power to remove. And you can't say that you fall back on some inherent power. Now just see. Just see 34 4B. Yes. The adjudicating authority shall, by order, replace the resolution professional if the board recommends the replacement by resolution. So where is that resolution? Right. No, we want to know whether there was any recommendation by you for reasons according to for his removal. All right. May I just point out one? In this, there is clear separation by as far as ITK, we just want to know which is the power exercised by the tribunal. NCLT, which is the power exercise. If that power is correctly exercised, obviously he is out. Yeah. I mean, there is a long judgment. We are really unable to understand which is the power exercise. Madam, there I think one section 16 of the general clause there. So the NCLT appoints. Just 1 second. Yes. Under the statute. Yes. Which provides for removal. Yes. Then law is very well settled. The law requires you to do something in a particular manner. You must do it in that manner. That's what you want to know from her. Whether there was a report, a recommendation by the board. Right. No, counter appeal, don't file counter. Just then give us, because this is appeal. You are not supposed to file counter appeal unless he has led upon some document which is not part of the record. Right. What affidavit you are going to file? You can't supplement what is there on record. What is there on record will show us. See, if we have not filed any document which is part of the record, we can always file an additional document. Yes, and that will in fact file his declaration to us, saying that he is authorized. Madam, actually is not authorized on that. That is one point. Yes. We also want to know that what is the procedure to be followed in such cases. He may fail also, we don't know. But see, such a long judgment, we are not able to understand which is the power exercise. Madam, that was what the improvement order reverted was the General Clause Act and Rule 11. See, the specific power in the statute. Yes, yes. To remove a particular officer. Madam. Then how can you fall back on General Clause Act Section 16? Madam. That's the question which you have to answer. Either there is no power, then you are right, section 16 can be invoked. Yes. If some authority has power to appoint, authority has power to remove. Right. But if there is a power, it has to be exercised in accordance with law. Right. All right, you file additional document.
Lordship, I have a small submission. Lordship, when an order is, the IDBI client will their petition on some allegations.
You are granting her time to produce.
I do prove it. It's a substantive, manifestly arbitrary.
Very good.
That is a doctrine.
You are appealing for respondent, sir?
Also,